Amrita madam, are we good to go?
Yes, sir. Yes, sir. We can start now, sir. Yes. So we can begin the session, sir.
Yeah. Please begin, because in next introduction of 4 to 5 minutes, all the participants will definitely join. Okay. Yes.
Sure, sir. Sure. Okay, sir.
Yeah. Go ahead.
A very warm good evening to all the dear participants, and a very warm welcome to our guest speaker, Advocate Vishwanath Patil, sir. Thank you so much for joining. Today, sir is going to enlighten us on the topic of menace of illegal and unauthorized construction and related laws in India. Thank you so much, sir, for accepting our invitation and joining us. I, Dr. Amrita Singh, will be the host for today's session, along with Professor Pooja Bijargi ma'am, who will be the moderator for today's event. I would now like to request our respected principals, Professor Dinkar Gitte, sir, to kindly address our guest speaker and the audience. Over to you, sir.
Thank you, Dr. Amrita. Good evening to one and all.
Good evening, sir.
Good evening, sir. I welcome our honorable guest today, Vishwanath Patil, sir, Advocate Vishwanath Patil, sir, who is an counsel for Municipal Corporation of Pune as well as Solapur. And the topic which he has chosen is very pertinent at the backdrop of that Kangana Ranaut's case, as well as now that today I came to know that verdict has been reserved by Bombay High Court. So not only that, but also this area is an upcoming area, and not only that, but it is contemporary. So definitely it would help all our participants, and there would be a lot of takeaways in today's session. Thank you very much for choosing this pertinent topic, sir. And once again, I welcome you on behalf of KLE Societies, KLE College of Law, Kalamboli, Navi Mumbai. Having said that, I'm also very much thankful to our management, Dr. Prabhakar Koreji, who is the chairman of KLE Society, Shri Mahantesh Kavadigimat, sir, who is MLC, Chief Whip Government of Karnataka, as well as who is the governing body chairman of KLE College of Law, Navi Mumbai, and Dr. Mallikarjunaya, who is the principal of KLE Law College, Bangalore, and who is a mentor. All the governing body members of KLE Society, secretary, all the members, all the participants, all the students, and all the teachers. Without wasting much of a time, I think now I would like to hand over this session to Professor Pooja Bijargi, who will continue as the session is scheduled. Over to you, Professor Pooja.
Thank you so much, Principal Sir. A very good evening to all the participants. With immense pleasure, I would like to introduce the guest speaker for today, Advocate Vishwanath Patil Sir. Sir has completed his BSc from Kolhapur University and pursued LLB from Government Law College, Mumbai University. He has worked as a legal trainee with Senior Counsel V.A. Gangal, Messrs. Manilal Kher Ambalal and Company, and Messrs. S.N. Gupta and Company. Sir has a total working experience of over 14 years. Sir has also worked as Mrs. Haryani and Company as an advocate. Sir regularly appears in various courts, namely Supreme Court of India, Bombay High Court, NCLT, DRT, just to name a few. Sir has been appointed as an panel advocate for Pune Municipal Corporation, Solapur Municipal Corporation, and Savantwadi Municipal Corporation. With this brief introduction, I welcome you, sir, and hand over the session to you, sir. Over to you.
Good evening, everyone. Mr. Principal Sir, Dinakar Datte, Pooja Bijargi, and all the staff and teachers and students and the advocates who have joined. A warm welcome, first of all, to all of you. And it's been a privilege, it's been absolute privilege to be invited by a prestigious institute like KLE and I have been privileged earlier also to have handled one of the Kaylee matter in Bombay High Court, and it was long back, around 7-8 years back. I had worked this matter with the senior advocate and now present Advocate General of Maharashtra, Mr. Kumbu Koni. So as such, the association is still going on. And today's topic which has been which has been menace of illegal and unauthorized construction. Am I audible?
Yes, sir, you're audible.
Yes, sir, loud and clear. Yes, yes.
You're audible, sir. Yes.
Yes. So the today's topic which has been given to me is about the illegal and unauthorized construction. In the drawback of Kangna Ranawat, I'm sure that everyone is wanting to know what is the overall law about this, how the courts are dealing with such kind of cases, and what is the overall procedure which is applicable in Maharashtra. So overall, in Maharashtra, we have a Maharashtra Municipal Corporation Act, which gives you a permission or for construction of building. When you have to construct a building, you have to approach a municipal corporation. You need to tender plans. You need to ask them with your maps, which particularly is done by an architect. So in Bombay, we have Bombay Municipal Corporation Act. That is now Maharashtra Municipal Corporation Act, which is 1888. And whereas in rest of the Maharashtra, the law which is applicable for the building permissions or the overall when you go for a building construction, which is to be applied as municipal corporation, the law there applicable is Maharashtra Municipal Corporation Act. Now, considering the fact that when a person decides to build a building, what he has to do, he has to make an application in a prescribed format, and that is in provision section 253, which says notice has to be given to the commissioner of intention to erect a building. So what is this? When we make an application, was it in just a normal application? No, you have to submit in a prescribed form. What would that include? That would include your plans, which is certified by your architect, along with total area, your title, etc., which has to be given to the relevant documents, which has to be submitted to the corporation, and that is under section 253 of the Act. So what does that include? So it would include for erection of a building, also erection of a building which is there, and erection of a building which is plans were granted but it has not been continued, but you want to construct further. So that is section 253, which grants you basically with the permission. And thereafter, what is the corporation? What the corporation asks from you majorly? The corporation would look from the point of view that whether you have a title, overall title to the property that has to be assigned by the corporation, then the documents which are pertinent, like 712 extract, property card, agreements, etc., which basically the corporation would look into, see that if you are a owner of the property or if you are a developer, whether you have got the rights to develop the property. On that basis, the application is being decided. Now, next comes under, if you see section 254. Now, section 254 of the Maharashtra Municipal Corporation Act goes on to the point of when a notice has to be given to make additions into the building. When you make certain additions to the building, let's say that when a person has to make certain additions, when you have purchased a flat, and if you have to make certain additions, which normally we would ask we'll go to the BMC. Here in Bombay, we'll go to the BMC. We'll ask permission to make certain addition, alterations which are there, or renovations which we normally call. If there are major renovations which are structural changes which has to be made, then we go before the the corporation, asking them to give us the permission for that regard. Now, the constructions which are there, which normally the BMC has to consider and which has to give permission. There are a lot of instances when individual flats are concerned. There are unless and until there is a complaint, or unless and until it comes to the notice of the corporation, they don't issue notices under section 254 or 258 of the Maharashtra Municipal Corporation Act. But when you see in a large scale of a building, permissions which are normally obtained by the by the builders or construction companies who construct big plans, the major issue sums up around them. Whether when a permission has been submitted, there are revised permissions which are always obtained from the corporation, maybe of a different thing because of the FSI issue, because of the lot more things which develop after once a permission is granted. There are things which happen that ultimately the developer has to go before the corporation asking him to revise the plans. The major problem which arises in these revised plans which happen, the builder changes the plan according to his whims and fancies, and then he start construction. So in this scenario, what happens is that the BMC or the corporation, if it comes to the notice, the issue notice under section 258, that is the power of the commissioner to cancel permissions on the ground of material misrepresentation, etc. Now, when I make an application to the corporation that please give me this building's permission, the plans are there, documents are there, etc., etc. there. Now the corporation issues the commencement certificate on certain terms and conditions which are listed over there. Thereafter, if there is a material misrepresentation which comes to the notice of the corporation, in one such case which I had the opportunity to appear for Pune Municipal Corporation, which was filed by Royal Developers, which is the state of Maharashtra, which in writ petition number 12571 of 2019. The dispute here was regarding a measurement of a land which was certified by the revenue authorities and tendered to corporation, Pune Municipal Corporation. So now, on relying on the documents and the plans submitted by this royal developers, Pune Municipal Corporation granted permission to them. After permissions were granted, things transpired that one of the rival person who had adjoining land along with them, he approached Pune Municipal Corporation saying that the boundary line which have been demarcated by the revenue authorities are wholly misrepresented. Am I audible?
Yes, sir, you're audible. Yes, sir.
One second. I think the screen has. One second.
So we can see your screen. Your video is visible.
Okay. So what happened is that a rival party who had a land adjoining to the this royal developers made a complaint to us. On the basis of complaint, we asked the this royal developers to give us documents on the basis of which the permissions were granted to come and give us. We asked for extra documents to justify the complaint which has been done by a rival party, and we sought documents from them. After verifying the documents, the PMC was of the view that yes, there is certain misrepresentation which has been done by the royal developers. So we revoked or we recalled the permissions which were granted. So in such a scenario, the royal developers approached Bombay High Court. So what the court has to say in this? The court, normally the provision which is there to revoke a permission, yes, it's there under the Municipal Corporation Act to entrusting the commissioner. If there is a material representation of fraud which is there under 258, he can very well do it. Now, what happens such a scenario when two rival contesting parties are there who claim that yes, this is what the land measurement which has been done is in my land has been encroached, and wrongly the municipal authorities on a representation of particular person has acted and have demarcated my land in their land. So in such a situation, what the court has to decide when such a revocation has been done by a corporation. Now the issue which came before the court was, can the corporation step into the shoe
Sir, we can't hear you, sir. Sir, sir, are we audible, sir? All the participants are requested to kindly be patient. We are connecting with sir. I think there is some network issue at his end. He'll be joining
What the
soon.
court had to answer is the whether issues of two rival before the court was we have act in a situation where a party information. Hello? Yes. One second. One. Can you hear? Hello.
So now you're audible.
Am I audible?
Yes, now you're audible. Actually, your voice was not coming in between. I think there was some network issue.
Huh. Is it audible now?
Yes, sir. Yes, sir. You're
Yes,
audible.
yes.
Okay. Okay. So, so now in a given situation, the court had put a question whether the corporation can step into the shoes of a court to decide a dispute between the parties. The answer straight away, the answer was no. But how did the corporation revoke or recall its permission? Then I invited the honorable court to the provision of 258, wherein the powers are given to the corporation in case of a misrepresentation of fraud which has been played. In normal circumstances, it happens that a person or a builder or a developer sometimes sometimes to with wrong documentation or XYZ, it happens that documents are not proper or misrepresentation has happened and they plans are sanctioned. But whether the corporation has the power, yes, the corporation has the power to revoke the permissions which are granted. Now the court, what the court had decided in this matter, the overall after hearing the rival contentions of the party, the court felt that no, the corporation cannot step into the shoes of a civil court and decide the rival contentions of the parties, deciding a dispute which is in the nature of civil nature. So what the court relegated is when there is such a issue, then the only authority or only judicial through the judicial system, that is the civil courts, you need to the civil disputes between the parties can be decided by the civil court. The writ petition came to be admitted. Now there were in a earlier this happened in a few months before the court had also opined in one of the matter with the Supreme Court in the matter of Sri Sai Reality versus State of Maharashtra. Sai Sri Sai Reality versus State of Maharashtra, reported in 2019 SEC online BMC 1 Bombay 1412. This was a similar case where the court decided the issue, which was confirmed by the Supreme Court, that no, the parties, when there are rival contentions of the party which have to be dealt in a which have to be dealt on the title of a party, in that case the corporation cannot decide on an issue of rival contention between the parties. It has relegated to the civil court. This is one such example when we come as a lawyer, when you are representing a corporation or a lawyer whose client has issued such a revocation of order, what needs to be seen is whether a corporation has acted or stepped into the shoes of a civil court to decide and adjudicate the rival contentions of the parties and pass an order. This is what the basic of rival contention now, because of high values or the land prices in places like Mumbai, New Mumbai, Pune, where the property prices have gone up by leaps and bounds. The disputes even might be with few meters or few square feet of plot of land where rival contentions that plot might earn a huge amount of money. So it becomes pertinent that people do go to the corporation, file complaints, see that such plans are revoked. So such are the situations. Now one more instances which somewhere around 90s, early 90s and 2000, which was 2000, somewhere around 2005, there was one PIL which was filed by Hari Hotmal Tanwani versus Commissioner Ulhasnagar Municipal Corporation. Now, as we all know, Ulhasnagar was a settlement area for people who came from West Pakistan. So the Sindhi community, after the partition between India and Pakistan, people who migrated to Bombay, the government gave certain lands, pockets of lands in Ulhasnagar for settlement. After the settlement, after the settlement of these people in these areas, the time lapse and people settled there itself. They constructed their own house. The developers came. The developers started building, constructing buildings, selling out flats. And in these all backdrop, there was no valid permissions which were obtained by many. So the question which came in the PIL, whether such mass scale of illegal or unauthorized construction which has taken place, can the can the can the commissioner on a mass level scale demolish or pull down these structures? The petitioner therein sought prayers exactly this, that the commissioner be directed to demolish these illegal buildings and the unauthorized construction which have happened. The court, after perusing all the records and hearing both the parties, passed an order which said that the illegal and unauthorized construction which have been demarcated by the corporation in its record shall be demolished. Pursuant to that, there is a big uproar because of a huge population being under the huge population under the threat of their shelters being pulled down. That moved the state government to make a regulation through an ordinance to regularize those structures. Those structures which were there, the structures, the ordinance came, the ordinance somewhere in 2006, the ordinance was passed by the state government of Maharashtra. The parameters were laid down. There were cases where the structures can be legalized, regularized, structures which cannot be regularized. So the ordinance per se divided the structures into two categories. One where the structures is old and it has been which very well can be regularized, which regularized, and structures which cannot be regularized, those categories of segregation of ordinance was passed. Pursuant to that, there was another PIL which was filed by the same gentleman, Hari Hutmal Tandwani, where the similar issue of regularization which was done by the ordinance was canvassed before the court. The court on the basis of the ordinance held that since the state government had passed, the structures which were there, illegal structures which cannot be regularized, so those structures which were there, the state government on the high court on the basis of those on the basis of the ordinance and the reports and the submissions which were canvassed before the court, held that it deferred by 18 months. It said that we give the time to the commissioner to take action in accordance with law for demolishing the structures. So now considering these illegal structures which are rampant in Bombay, if one can say that the slum rehabilitation projects which are implemented in Bombay, or the Slum Act 1970 or Maharashtra Slums Act 1971, previously which was regulated to 1995, the cutoff date of people who could be where a slum rehabilitation project could be implemented, or a cutoff date could be was for 1995, for January 1995. That's the uh, photo pass which was granted by the authorities, the BMC or the SRA authorities. Those were included in the annexure 2, which was prepared for redevelopment of a slum pocket. A classical example can be given of the slum pockets which are in BKC. There's this one slum pocket which is very huge slum pocket, is Bharatnagar Slum Rehabilitation Committee, which was there, which was in the BKC. The structures which were there, they were prior to 1995, and there are structures which were came after 1995 until until recently. There are structures which are coming up all over Bombay. Now, considering all this in the viewpoint of Maharashtra Slum Act 1971, the cutoff date which was there 1995, 1st January 1995, the successive government, they increased the cutoff date. So let's say a person who was held eligible in 1995 on the redevelopment process, started somewhere in 97, 98, and the successive government which came in 2000, they extended it until 2001, 2005, and 2010. So the structures as such on a mass level, which we say that the Bombay is, the menace of these illegal structures, which we see is in slum pockets, major slum pockets, which have been, which people from migrated city, people from cities which come to Bombay, they don't have place to stay. They're poor. They don't have place to stay. How do they get a place? They buy the slum pockets, they pay, they stay, or go and start staying with a wherever they get placed. And with time, with lapse of time, such structure, because of the political clout which is there, because of the vote bank, which majorly is one of the biggest consideration which we see, those structures are legalized. In a sense, it's legalized when the extension, when the period is extended, those structures which are there, those slum huts which we call, those are legalized in a sense. That is by that is by the act itself, which is under the Maharashtra Municipal Corporation Act. Now, coming back to the corporation laws, which says, now what happens to buildings or structures where a permission is granted and the builder or a developer or owner violates those plans and construct to his own wish. So now under 260 of Maharashtra Municipal Corporation Act, which says the proceeding to be taken in respect of buildings or work commenced contrary to law. Now, one of the classical example which is very much fresh in the minds of the people is 351 notice which was given to Kangana Ranaut. The issue there, which is subjudized before the Honorable Court, pertains to a notice which was served by BMC under Section 351 of Mumbai Municipal Corporation Act, stating that since the permissions which were granted by the BMC, there was the structures or the interiors or the overall structures which have been constructed inside the building have the plans have been violated, and as such the notice was given. Now, the main issue which transpires as a law student or as an advocate, when we see when a section 260 notice is given, what does the 260 notice contemplates? The 260 notice contemplates that a person has constructed, developer, owner, or etc. Has constructed something contrary to what has been given. So basically, they would say that you please tell us why this structure should not be demolished or should not be pulled down for reason that it's contrary to what the what has been submitted, what has been approved to you, or what we can say is an offending structure which has been constructed contrary to the provisions of law. In such a situation, one can ask whether a show cause notice or a personal hearing is necessary. Now, normally when such a show cause notice is issued, or a notice under Section 350, 260 of Maharashtra Municipal Corporation or 351 of Mumbai Municipal Corporation is given, normally a person would say that I need to be heard before any orders is passed. I need to be I have to make certain representation. I have to rely upon certain documents. That very well is something which the corporation asks, that give something which we can decide on the basis of orders can be passed. Now, one such issue came before the court before the Supreme Court, where the Supreme Court had the occasion whether a personal hearing should be given in the case of 260 or 351 of Maharashtra Mumbai Municipal Corporation Act. A notice is issued to a owner for offending structures or buildings which have been constructed contrary to law. In this matter before the Supreme Court, the question was whether personal hearing is necessary. The Supreme Court, after hearing the rival contentions of the corporation as well as the party, held that the principle of natural justice or the principle of audi alterum paltrum requires that a person, a person's sufficient compliance would be that a person should be represented, heard. That heard is something which can be on the basis of a reply which is given to the by the owner or developer to the corporation, and it specifically laid that no personal hearing is necessary. It is absolute discretion of the commissioner or the corporation to decide on the basis of replies, on the basis of documents which has been submitted to the corporation. The corporation can very well, if it is satisfied that no further documentation or no further hearing is to be, or extra document is to be required to to understand the issue, then the corporation can pass immediately orders, or the corporation or the commissioner is absolutely at liberty to call for the parties for a hearing and then decide the issues. Now, the same issue again came up before the Bombay High Court in Sopan Maruti Thopte versus Pune Municipal Corporation, where in 1996, the scope of this section, for the scope of the scope of the writ petition was per se on the section 261 of subsection 1 of Maharashtra Municipal Corporation and section 351 of Bombay Municipal Corporation, on the issue whether a personal hearing was must or whether a personal hearing is not mandatory when a section 350 section 351 and section 360 subclause 1 of Maharashtra Municipal Corporation notices are issued. The court was of the view that when the similarly on the basis of the Supreme Court Supreme Court judgment in the matter reported in 1983 to SCR 676 in the Municipal Corporation of City of Ahmedabad versus Ben Hiraben Manilal. The Supreme Court on these basis, on a similar line, the Sopan Maruti Thopte versus PMC, the issue was decided that it is the justifiable grounds of hearing, whether hearing is necessary or no, is something which is left out to the commissioner. The principles would be, it's not mandatory. It is absolutely not mandatory that a personal hearing has to be given. All that is required is reasonable, show cause notices. When a show cause notice is given, replies are sent by the parties. On the basis of replies, on the basis of those replies, the orders are passed. Reasoned orders are passed. Now, very well we know that when such orders are passed, normally it's a formatted order which we call that. Corporation has said on the basis of the documents submitted by the, and so we are of this considered view that the owner or a developer has made structures which is contrary to the building permissions which was approved by the corporation. Now, one more thing which normally as a practicing advocate which we see is when I have to represent such a person against whom an order has been passed, I would per se see whether the order is reasoned order, which normally the courts normally say when authorities pass order, they have to apply their mind and pass orders. They can't mechanically, on the basis of notice which is issued, say that the structure is illegal or contrary to the provisions of conditions which the commission certificate is granted, that can be pulled up. Now I will hamper on these things that a reasoned order has to be passed, wherein the grounds which I have taken in my reply, those have not been considered, or fair enough, those have been straight away rejected, and hence the order has to be set aside. This is what a challenge in a writ petition when we go under section order passed under section 260 to the High Court. This is what normally we see. Now coming back to Kangana Ranaut and Municipal Corporation, Mumbai Municipal Corporation case with a dispute. Now the structure notice was given to her. She had certain representations which were made to the corporation, and immediately the next day the corporation passed order and the demolition was carried out. Now, intermediary, she tried to approach the honorable court. She submitted that since I had enough documents to substantiate my case, I should have been given more time to be heard, but rather the corporation in a haste manner they passed order and they have carrying out construction. The petition was heard. everything is in there's a media trial as such which happened. The overall the court, the issue which was to be considered, the two contentions which were there before the on behalf of Kangna which were canvassed, that there is a recent Supreme Court judgment which is passed by the Supreme Court in the Municipal Corporation of Greater Mumbai versus Sunbeam High Tech Developers Private Limited. The Supreme Court has issued certain guidelines with regard to whether the notices which are issued under 260 or 350, what is the period under which the replies have to be sent, what happens after the replies are sent, orders are passed, whether the demolition has to take immediately or whether there is a cooling period, certain cooling period which is given to the owner developer who has constructed structures contrary to the provisions. The Supreme Court laid down certain guidelines per se, saying that there are certain days. There are once the submissions are put forward before the corporation has to consider and then pass a reasoned order. Now, at para 23 of the order, the Supreme Court per se, the Supreme Court, looking into a larger scale of issues which are rampant of illegal structures which are coming up entire country, they a crystallized procedure had to be made up. What happens when a notices under section 260 or 351 are issued, and what other or after the order, whether the corporation can immediately go and pull down the structures. These, in considering these overall facets, the Supreme Court passed directions. Now, going back to the judgment, the Supreme Court widely said that in a corporation which has more than 50 lakh population, or the population where the structures, rampant illegal structures have come up, and the records of those rampant structures are not maintained, or which has been not which has been these structures which have been which have not come to the notice of the corporation, how to locate these illegal structures. The Supreme Court says that the technology has to be utilized, and a geomapping has to be done of these structures in the corporations where the population is more than 50 lakhs. The corporation has to have a geomapping of these structures so that the corporation has details, photographs, etc. Of these structures. When such notices are issued, the notices have to be issued with the photographs of the structures which are illegal, or the structures where the after coming up they have made certain alterations in such building. Thereafter, the Supreme Court says that if a notice under section 260 or say 355 days, section 351 of the Mumbai Municipal Corporation Act is issued, within how many days the reply has to be sent? The show cause notice, you are called upon to send a reply or submit documents along the proof of your structure. The Supreme Court says that 7 days notice has to be given to give a reply. In case a seven days submitted by the developer, owner, etc. After submission of the reply, the reasoned order has to be passed. If there is no reply, which, let's say in a given situation, a person or a developer doesn't file a reply, then what the consequence of it be? Supreme Court says immediately it has to be demolished. The structure has to be demolished. Then where the replies are filed and the documents in regarding the offending structures which are submitted to the corporation, what happens then? In that case, the 15-day the order, a reasoned order has to be passed stating what, considering all the documents which are placed with the corporation has, in its considered view, finds that the structure is offending structure and the building structure has been contrary, come up contrary to the provisions of law. Now after the notice, a cooling period of 15 days has been given to the person developer. He can approach the High Court or a statutory authority under the provision of law to go and agitate the order or canvass that order before the higher court. So this per se dates which were there, particularly dates that a cooling period of 15 days were not there earlier. So the Supreme Court basically crystallized these these dates, per se dates, when a notice is given, where replies when to be given. After, if no reply, what happens immediately thereafter, and when a reply is there, pass reason order, and you have to wait for 15 days until which the structures cannot be demolished. Now, when you look into this, when you have to look into this judgment, whether the municipal corporation of Mumbai in Kangana Ranaut case has immediately taken action, whether there were valid reasons, that is something which will be passed, the order will be passed by the Honorable High Court. But Supreme Court in this Sunbeam High Tech Developers Limited has explicitly made it clear, making out the guidelines, giving out the guidelines on how the basis of this the corporation has to act. Now there are certain stop work notices order which are given. Now the stop work notice, where the corporation comes to an understanding, whether it is come to the corporation notice, if there is a structure or a building which is where construction is carried out against the provision of the or the conditions laid down in the commencement certificate, then the corporation can very well issue notice to the builder or the developer, asking him to stop work notice, which we normally call. So in that case, what is the time period under which a person has to reply? The Supreme Court here also says that a person has to reply within 24. Person has to reply within a prescribed period of 24 hours, and if there is no reply, then the demolition can immediately take place after that. In case where the notice is served and the reply is filed, in that case the same process, that a person has to, after the reason order is passed, wait for 7 days, and thereafter the demolition can take place. In between, if the developer or owner, after reason order is passed, he can approach within the cooling period of 7 period, he can approach the High Court or a authority agitating the order passed by the corporation. Now the Supreme Court here in Sunbeam judgment once again reiterated the use of technology in services, where when the informations are sent for a building permission, normally the email address, mobile number, etc., sometimes they are missing. So the defenses which are always taken, that the notice is not served, or the notices which is served on a person who is not authorized to take up the or receive those notices. So the Supreme Court laid down the said that the use of technology has to be taken care into when such building permissions applications are made. When applications are made, the email address, WhatsApp number, the telephone number, mobile number, everything details has to be given when a person makes a prescribed application. Along with that, it also says that the notices have to be served through WhatsApp and email, which is a valid, which will be considered valid on the addresses which are given by these persons. Now, the service part which is there, the most of the times when we argue before the court, this is one of the main issues which is taken up by the lawyers who are representing such developer or a owner, that the notice is not served, or notice is not issued by a person who is authorized to pass an order. So those issues which culminate into ex parte or which culminate into setting aside those order or a fresh notices to be fresh notices are issued. So this judgment per se covers that, a person, a designated officer who's authorized to issue an order, he has to hear them by laying down those dates, the dates which are given. The orders have to be passed in accordance with the dates, and thereafter the structures can be demolished. Now, what are the after coming to this about the parameters under which the structures can be categorized and the notices when issued, the cooling period, the replies, etc. When can be when these structures can be pulled down. Now, moving ahead from this, the section 267A of the Corporation Act, Maharashtra Municipal Corporation Act, uh, gives the power of the corporation to levy penalty on the illegal buildings and the buildings or structures which have been constructed contrary to law. This provision is included for two reasons. One, that the offending structure or the person who has constructed the offending structure pays for the illegal structure. Along with that, in view of this notices which are there, he not only pays, but the structures, if they are constructed contrary to the provision, those structures can be
Sir, am I audible to you? Sir, am I audible?
There is some network issue, Pooja ma'am.
Yeah, ma'am, I'll just check.
Yeah, participants kindly be patient for a few minutes. Sir will be joining us again.
those are pulled down. And now the next part is the reporting.
Sir, am I audible?
Hello.
Yes, sir. Yes, sir.
Huh.
So you
Am I audible?
were not audible that time. You are audible now.
Okay. Now coming to this section 268, the power of commissioner, or section 354 of Mumbai Municipal Corporation Act, where particularly which lays down that structures which are likely to fall or structures which have become structures which are in a ruinous condition or which are dangerous, the commissioner has the power to issue notices and asking the owner of the buildings, or it's just a society, the society has to submit its replies, its documents, a structural audit report which is there normally, why the building or a repairs can why the building should not be pulled on, or it can be waived off by the building can be repaired. So now, when you see in the background of situations in Bombay in monsoon, and particularly when we talk about Bhiwandi, particularly when we talk of Vendi Bazaar, Muhammad Ali Road, or where the buildings are so old, these are the old structures in Bombay which cannot be repaired or which cannot be there is no other option but to pull down the buildings. And we have seen in past, recently in Malegaon, Bhiwandi, recently in Bhiwandi, a building collapsed and the people who lost their lives. So these issues which are there, how the High Court have dealt with these issues. In recent past, when a notice under section 354 of Maharashtra Municipal Corporation Act is challenged, or section 268 of Maharashtra Municipal Corporation Act is issued, the provisions say if there is 30 there is a 30-year period, the 30-year period which is given to a building. If a building is more than 30 years, then the structural audit report has to be submitted by that building to the corporation to assess the strength and the stability of a building in a periodical manner, which has to be submitted. In case the corporation comes to an opinion that the building is hazardous building and it is in the verge of falling, the corporation can very well issue a notice under 354 or section 268 of Maharashtra Municipal Corporation Act, and asking the owner or the developer, etc., the owner or the society, or or if it is a building, whoever the owners are there, to ask the building to to pull it down. Now, when such a petitions are challenged in High Court, the High Court have taken views. There are lots of judgment which there are contrary views have been taken, wherein in view of structural stability report, there are rival structural stability report which are obtained by the society, as well as the BMC, which also gets its own audit, internal audit of the structural strength of a building. In such a scenario, when a writ petition is filed, there was this tendency wherein the court were of this view that when the immediate interim orders were passed, there was an undertaking which was taken from these people, that in case a building falls, or in case if a building, because of its strength which is weakened with due years of more than 30 years, 40, 50 years, then the entire consequences would be entirely on them. If there is any injury to man or in a building, or a consequence of such a collapse which happens, then the entire responsibility of compensation, etc., shall be on the person who have approached, also or before the petitioner. Now, this view has been on and off, on and off. The courts have considered asking them to tender an affidavit or undertaking before the court, which very well we have seen time and again in matters the same system has been implemented. Now, recently, Justice Dharmadhikari and Justice Patil have taken a contrary view, saying that the responsibility of the lives not only vest in an individual but also in the corporation and the state. They are well within the powers that every individual, or if a building collapses, the people who are walking on the street, or the buildings which are next to it, should not be damaged, or any injury to the man and the land should happen. In recent judgment in 2019, in two of the judgments, Justice Gupta and Justice Dharmadhikari and Justice Patel have taken a contrary view that no, we are not taking any undertaking from the petitioner. The petitioner have to vacate the petitioner have to vacate the building for the reasons that the undertaking is not the only way of securing a stay. If the merits are there in the case, the court would grant. If there are no merits in the case, then the court should not take any undertaking and pass an order of ad interim before the or ad interim. Going a step before these orders culminate before the High Court, when you see that when notices are served under section 268 or section 470, section 354 of Maharashtra Municipal Corporation Act, there is some differentiation in these two acts. Here in Mumbai Municipal Corporation Act, there is a committee which has been set up, which decides these illegal these structures which have become ruinous, or which are old and dilapidated. Whereas in Maharashtra Municipal Corporation Act, there is no committee, but there is a commissioner or the designated officer who order. Now, the contentions which normally go before a designated officer or a committee is a structural stability report. Normally, there are structural stability report which are obtained by the rival parties and submitted, and on that basis the orders are passed. Even these orders, structural stability report, which are submitted, are challenged before the court, now taking a view on overall view on the aspect of whether the court can step into the shoes of an expert opinion to decide a structure is illegal, a structure is ruinous, a structure cannot be repaired, a structure which cannot be repaired, and structure has to be pulled on for reason that it might fall anytime. The time and again, and the courts have also have opined on this issue that a court cannot stamp into the issue of an expert opinions. They cannot replace or they cannot write their own order stepping into the shoes of an expert. All they can decide is whether the due process of law has been followed, whether proper hearing, whether proper submissions has been made, whether the submissions which are made before the corporation or before the designated officer or before the committee, whether they have considered the material before them, and on that basis the orders are passed. So overall situation, when we see these ruinous buildings,
Sir, can you hear? Sir, can you hear us? Sir, you're not audible. Dear participants, there is some network issue at sir's end. Sir will be back with us soon. Thank you so much for your patience. Sir will be joining soon. There is some network issue at his end. Thank you. All the participants are requested please be patient for a few minutes. Sir will be joining us again and we will be continuing with the session. Thank you so much for being so understanding. We'll be starting soon.
Amrita madam, I think sir has entered.
Yes, sir. Yes, sir.
Madam, unmute
Sir,
sir.
am I audible to you?
yes, am I audible?
Yes,
Yes.
sir, you're audible. Yes.
I think the time has also, over 1 hour which was given to me. I'll just sum up in 5 minutes about the last section, which is about which says about structures which are totally illegal, or what I just discussed with you about the slum rehabilitation projects, or the rampant illegal structures which are there, or the slum huts which have come up, and how the corporation or the state government has dealt with such an issue is by regularization of these structures, slum huts which are there particularly in Bombay. Now, Section 478 of Maharashtra Municipal Corporation, it gives power to a commissioner, power to the commissioner, to a designated officer, to issue notices and pull down such structures, huts, buildings which have been constructed without any permission. So in a given situation like a slum area in Bombay, where are no permissions which are whatsoever are obtained uh, from the corporation, these slum huts which are constructed on a pocket of land, and with passing of years, there are structures which go on increasing, ultimately with the help of these political clot, or what we call as the vote bank thing. The overall these structures culminate into a cooperative society, a proposed cooperative society, and projects, and through holding through a hand in glove with the builder, the projects are put before a slum rehabilitation authority. And from 1995, where the state government had passed these cutoff dates, and till date these cutoff dates have been increased until 2011. So the overall menace of these illegal structures and unauthorized structures, we have discussed the provisions which gives the power to the corporation, which gives the power to the corporation to pull down these structures, to revise, to alter, and there's a separate we need to have a separate webinar when it comes to slum rehabilitation project, how the state government has been extending these deadlines, and having these slum rehabilitation projects implemented in Mumbai. So I'm sure I've had little on light on these issues about the illegal structures and the unauthorized structures, and the provision which in both these Maharashtra Municipal Corporation Act and Mumbai Municipal Corporation, and what the High Court and the Supreme Court has to say on these structure, and how these structures can be pulled down, and what the process is. I thank you once again, the principal, Mr. Dinakar Datta, Pooja Bijjargi, and all the teachers and students for having patience to hear me for 1 hour. Thank you so much.
Thank you so much, sir, for your valuable session. I am sure the participants have learned a lot from this. And the case laws that you have shared, the experiences that you have shared, that must have increased their knowledge about this topic. Thank you so much, sir.
I hope. I hope.
So with your permission, can we take a few questions of participants?
Yes, why not? In fact, I was going to ask you that.
Yes, thank you, sir. So the first participant, he's asking, what are the different preventive measures taken against those who do illegal encroachment?
Illegal encroachment on what? What does she mean? It's a private land or a government land?
With my knowledge, I think it is about the public property.
Okay. See, the lands which are in particularly in Bombay, where the lands, vacant lands which are there, the government always has its record with them. But with the influx of population in Bombay, with the influx of workers who come to Bombay, there cannot be a system of though the laws are there, but the laws are not strictly implemented. Once these structures start coming up, the powers which are there, which I mentioned under section 260 or 478, which particularly says that there is a power to when there is no such permissions which are obtained by the from an authority, the corporation can very well issue notice and pull down those structures. But in view of silent or just having a closed eye to these structures, the structures come up. These slum pockets, which I particularly mentioned, these are one of those issues where the structures are small. Maybe now because the structures have gone 1 + 2 or 3, even we can see in Bandra station that the structures have gone. But because of the will which is there to implement, or the political backing which these slum slum pocket people would pitch through a politician. The administration has never taken any call on these, in spite of notices being in such issues. Many a times notices are issued, but they are not implemented. One such classical example, which today happened before
Thank
the
you so much, sir,
court.
for the wonderful session. And
Hello. Hello.
Sir, I think there was some disturbance. Sir, sorry for the interruption. So,
Am I audible?
Yes, sir, you're audible. You're audible.
The situation is, in spite of notices being served, the will of the authorities to give the notices logical end by demolishing them. So there are all laws which are there under the Corporation Act also Maharashtra Regional Town Planning Act, which I forgot to mention about particular sections, where the permission has to be taken under 44, 45. What are the provisions where we can, after the permissions are refused or conditions are put, they can well go in an appeal under section 47 before the state government. But addressing your question, it is very well the laws are there. As I mentioned under section 471, notices can be served, the structures can be demolished. Either it is a private land or a government land.
Thank you so much, sir, for that answer. The next question is from Nazma Sheikh. She's asking, if building is illegally constructed, what is the court's decision, or what would be the court's decision?
Okay, now when the notices are issued under section 260 or 278 or 351 of Mumbai Municipal Corporation Act, and in view of the Municipal Corporation of Greater Mumbai versus Sunbeam High Tech Private Limited, the procedure is laid down. Even the acts provide that show cause notice why the structure should not be pulled down. That is what the reply is construed to be. Reply is construed and the order is passed. When the court have to see such a situation, the court analysis whether the corporation has followed due process of law in issuing the notice, and the records which have been sent, or the show cause notice against which replies are filed, whether they have concrete evidence to show that the structure is authorized structure and they are valid structure. Based on this, the court shall pass their opinion or pass their orders.
Thank you so much, sir. The next question is, the participant is asking, is action taken against illegal religious structures on the roads or footpaths?
That's something which is quite sensitive issue. I would answer in this way. It happened in one writ petition where I was representing the Municipal Corporation of Pune. There are rampant masjid or temples which are scattered around the city. So the petition, one of the public spirited person had approached Honorable Court saying that since these structures are illegal, the orders are passed to demolish, but there is no will of the authority to demolish those structures. So I was representing Pune Municipal Corporation. It was just before Justice Kanade, then Justice Kanade. The argument on behalf of the corporation was that as a authority, as a building permission authority, we have passed orders, and when the passing of orders, after giving it a logical end, when these structures which are sentimental and religious issue, there is a law and order situation. But this is our plight, because we could not demolish it for reason that it was a law and order situation which could very well convert into riots. So the court passed orders saying that the police commissioner should give assistance. So there are instances where the court have been very strict. There is no leverage can be taken to the issue that it's a religious building. The court will never entertain. If it is illegal, and it has to be demolished.
Thank you, sir, for that answer. The next question is from Dr. Kumara. He's asking, sir, on what grounds Kangana Ranaut's office was destroyed by Mumbai Corporation, that too in such a pandemic situation?
Okay, now this is a good question, for reason that after the after the lockdown was declared by the state government and the central government, the High Court, a bench of 4 judges, have passed an order stating that auction, sale, attachment, etc., they will be stayed. That all the corporation statutory bodies and the agencies, government agencies, that includes banks, etc., to an extent, where attachment after the lockdown, there will be no execution of those orders per se. Now, during this, the order which was passed in the March, it came to be extended, and recently it is extended until 31st March, 31st October 2020. Now, in the backdrop of this, how did the corporation demolish the structure when the lockdown is there, when the orders are there? Now, that is a matter of argument before the court, which is sub judice. I think I have demonstrated with the Municipal Corporation of Greater Mumbai versus Sunbeam High Tech Developers Private Limited, the process which the Supreme Court had laid down. I'm sure that the council representing the corporation have put forward their replies, and I'm sure they will all wait for the judgment of the High Court. Let's see what the High Court has to say on that.
Yes, sir. Thank you so much. So the next question is from Advocate Nikita. She is asking, sir, can you please give us some clarification on the concept of photo pass given to the slum dwellers?
Okay. Now, the photo pass which are given are on the basis of slum pockets, slum hut which is there. It is given. Now, the system earlier was to get the benefits which are given under the statute under the Maharashtra Slums Act 1971. A person has to have a photo pass, and the photo pass is an identity of holding a structure. The cutoff date at that time the state government issued was 1995, 1st January 1995. The later on it has been increased. So basically a photo pass, photo identity, photo pass which you call, is an identity of a person holding a slum hut.
Thank you so much, sir. The next question is from two of our participants, Mirza Beg and Shashikant. Both of them are asking, sir, why does corporation don't take any action relating to unauthorized construction while it is in the construction period? Why is it that they are negligent at the first instance?
Can you please repeat the question again?
So they are asking why corporation does not do anything when unauthorized construction is still going on. Why after the completion of the construction, they take the actions?
Not necessarily the actions are taken when the buildings are completed. There is a provision which I mentioned about section 270, which is stop work notice which is given, which also I mentioned about this Supreme Court judgment. In case where a structure, it is when the corporation, the ward officer of a corporation is the authority who has to keep an eye on these illegal structures and the structures where permissions are given, and the building which has been constructed contrary to the plans which have been approved. He is the authority who issues the notice on behalf of the commissioner. So as soon as the authority comes to the notice that the structure is illegal, or the structure is being constructed in contrary to the law, the notices are issued. But it happens that many a times that these structures go unnoticed. Maybe big building, or you can call small buildings. These structures go unnoticed. But at the time when a builder or a owner goes for an occupation certificate, when you go and ask the commission, the corporation, to give me occupation, so that what we call is a completion certificate, that time when a survey happens, when a survey is conducted by the corporation, that is the time when the corporation comes to notices that there is plans which have been given and the structure is contrary, which has been completed. So for that reason, the completion certificate, the occupation certificates are not issued, or the completion certificates are not given. So it's not that it happens because of cities being big, the strength of the officer staff being less, but certainly it happens that notices are issued, though delayed. The provision is very per se clear about that. There are provision during the construction also. Yes, the notices can be given and it can be pulled down.
Thank you so much, sir. So the next question is from our college student, a TY LLB student, Vaibhav. He's asking, sir, if there is an illegal construction done by someone and that person is now asking the government to buy that property by paying the required amount of money, can it be done? Is there any such provision?
No, there is no provision wherein such illegal structure can be taken over by the government. Under the Maharashtra Municipal Corporation Act, Mumbai Municipal Corporation Act, or Maharashtra Regional Town Planning Act, there is a concept where acquisition of land is there, of the reservation of land. In a place where land is reserved and the corporation under the development plans of a city which is issued under Maharashtra Regional Town Planning Act, if the land has to be acquired and if there is a structure, then the structure has to be pulled down first. If it is illegal, then the land has to be purchased by the state government, by the corporation. When we see that lands which have been reserved for hospital, reserved for playground, reserved for school, etc., or there is a reservation for a particular recreational activities, those lands, there cannot be any illegal structures. One classical example I can give you is of recently, around a year or back, after the central government decision to construct the toilets, the corporation had constructed toilet at their whims and fancies. They were at discretion to select a place in where defecation took place and to construct the toilet. There are many instances where such decisions to construct those toilets have been challenged, and one such instances where the courts were pretty severe on the corporation to construct toilets on a land reserved in a development in the corporation which was reserved for a particular recreation. Those structures have also been asked by the court to pull it down. So as such, the answer is no. There cannot be any structures which can be bought by the corporation if it is illegal. Where reservation is there and the corporation has to acquire that land, then the land has to be acquired clean with clean title.
Thank you so much, sir. With your permission, can we take up the one more question?
Yes.
So the next question is from Mr. Arif Wani. He is asking, can a structure be raised beside a highway? Is it a legal action?
Sorry?
Can a structure be raised beside highway? Is it legal?
When you submit an application under Section 253 of Maharashtra Municipal Corporation Act or Section 44 of Maharashtra Regional Town Planning Act, the corporation looks into the issues of road structures which are abutting the road, and then the permissions are granted. And in the development plans which are sanctioned for the city for a 30-year period, when the development plans are sanctioned, which I said an example of a reservation of a plot of land. In a similar way, when a land in the development plans, if a road has to be widened, if it is a 30-meter road, a 60-meter road, or a 90-meter road, if it has to be widened and it is in the development plans that has been sanctioned that the road has to be widened, there cannot be any permission which can be granted by the corporation which is abutting and which comes within the way of the sanctioned plan for widening of the road. So the answer is the corporation would first see whether the building which is to be constructed closer to the road is falls within the building plan, falls with the sanction plans, development plans, and then approve it. Without that, they would not do it.
Thank you so much, sir. Thank you for sparing your valuable time with us and giving such an important session, such an informative session to our participants. Thank you so much, sir. And thank you again for accepting our invitation.
I once again thank the principal.
Thank you, sir. Thank you very much.
Mr. Datta, and Pooja and all the teachers of the college for giving me this opportunity. And overall, I hope that there is some good discussion about the topic of illegal structures and
Sure.
illegal unauthorized structures.
Thank you so much, sir.
Thank you.
Yes, I request Amrita ma'am to kindly continue with the session.
Thank you so much, Pooja ma'am. And once again, on behalf of KLE Societies, KLE College of Law, Navi Mumbai, I extend sincere gratitude to Advocate Vishwanath Patil sir for coming in and sharing his experiences and knowledge with all of us. We all have witnessed a wonderful session today, sir. Thank you so much for that.
Thank you so much. Thank you so much for inviting me.
Thank you, sir. I would also like to extend my gratitude to the respected members of the KLE management for their blessings. Dr. Prabhakar Kore, sir, Chairman of KLE Society, Mr. Mahantesh Kavatkimat, sir, Governing Body Chairman of KLE College of Law, Member of Legislative Council and Chief Whip of Government of Karnataka, Dr. J.M. Mallikarjunaiya, sir, Principal of KLE Society's KLE Law College, Bangalore, and the Director of KLE Law Academy, Bangalore. And of course, our respected principal, sir, Professor Dinkar Gitte, sir, for always giving us the right path, showing us the right path in which we all should move, and continuously encouraging us to take these sessions regularly. Thank you so much, principal, sir. I'm also thankful to Professor Pooja for the wonderful moderation, and of course Professor Salim Khan sir for standing there as a team for successful completion of the webinars. I'm also thankful to our students who have worked day and night tirelessly, making webinars a grand success. And of course, last but not the least, our dear participants who have always joined us in overwhelming numbers and have put those interesting questions to our respected guest speakers. Thank you so much, one and all, for gathering here today. And thank you so much again, Vishwanath Patil sir, for coming and sharing your views. Thank you so much, sir.
Thank you so much for having me here.
Thank you, sir. Thank you. So with this, we'll end the session. Thank you, one and all.
Thank you.